Hey there, I'm the Madcatster. Am I glad to see you here? Well, wouldn't you know, I looked and there is a new development in the whole Janet and Lauren the Mortician and the Girlies lawsuit. As you know, in one of my previous videos, we talked about how the court had granted partial summary judgment to the defendants, to the Girlies, and basically all of the counts had been dismissed and all of the defendants have been dismissed except Lily Marson, who had 3 counts left against her. Well, now, Janet and Lauren have done something that I think doesn't make a whole lot of sense. We're going to talk about it. You know me, I've got the deets and all the receipts, so buckle up and let's go. So I'm here with Sybil the Enforcer, who's sleeping. And Antoinette and my little squirt are sitting right here, too, to help out. So Janet and Lauren the Mortician had summary judgment granted against them and in favor of the defendants, and that's Lily Marson, Jessica Vasquez, Becca Day, and Caffeinated Kitty, Casey. So 2 whole months went by, okay, with nothing happened. They didn't file anything with the court to contest the decision in favor of the Girlies, and then 2 months later, they now have filed a motion to amend their complaint and to file a 3rd amended complaint. So while there's nothing that says they can't try to do that, it's really bizarre for a couple of reasons, in my opinion. The first is, why did they wait 60 days before they filed anything? That just seems odd. And second of all, why didn't they file to amend the complaint when the Girlies filed for summary judgment before the court had rendered a decision? So I was interested to see what Illinois, which is where the federal court is for this, what Illinois cases say about doing this type of thing. And I found something. There's a case that's pretty similar. So we're going to take a look at that in just a second so I can show you what I'm talking about, why I think this is so strange. So basically what they're doing is saying, now we know that the court has dismissed all of this from our complaint and all that's left is Lily Marson in 3 counts. So we're going to use the court's reasoning now and we're going to go and try to rework our complaint now and try to come back in with an amended complaint, even though partial summary judgment has already been granted. It just seems really weird to me. And they filed their motion. They filed the 3rd amended complaint or proposed 3rd amended complaint. And then they filed a redlined version, which I've actually never seen before. Is basically, you know how when you make changes and corrections in a Word document, it'll redline and show you what's been changed. Well, they filed the redlined version along with the clean amended version. It just seemed really weird to me. So I think it's strange. I wanted to see if it was just me thinking that was strange. So I went and looked at some of the case law in Illinois, and this is what I found. So there's a case from the U.S. District Court for the Northern District of Illinois, and it's a case that's called Young versus Murphy. It was decided in March of 1995, so it's not that old. And this is what they had to say regarding this exact type of situation. They said a district court has broad discretion to deny motions to amend in cases of undue delay, bad faith or dilatory motives, repeated failure to cure deficiencies by amendments previously allowed, in undue prejudice or futility. And then in this particular case, this is what the court had to say. The court believes that Mr. Young has filed his motion to amend the 3rd amended complaint after partial summary judgment has been ordered, a judgment on the remaining issues is pending, and the briefing schedule on the remaining issues is almost complete for the purposes of delay. So they thought that he was doing this to try to delay the process. The court finds that Mr. Young's delay in bringing this motion constitutes grounds to deny the motion to amend the 3rd amended complaint. And then they cite to a case here that in that particular case, it said it found no abuse of discretion in denying motions to amend the complaint where the motion was filed after discovery was completed, motions for summary judgment were fully briefed, and witness and exhibit lists were already submitted. Now, in that case, they hadn't even rendered a decision on the summary judgment motion. It had just been filed. And then they said to another case, it said finding no abuse of discretion in denying a motion to amend complaint when motion was filed after discovery was completed and after defendant had moved for summary judgment without adequate explanation for the delay in an apparent attempt to avoid the effect of summary judgment. And that's exactly what I thought when I saw what they were doing. I was like, this is kind of strange. They're, first of all, not to have done it when the motion was still pending for summary judgment, but then to wait a full 60 days? And they're saying, oh, it's not to delay. And you'll see, I'll show you in a minute what they are claiming and how they're trying to justify doing it now. It said the clerk of the court is therefore directed to deny Mr. Young's motion to amend the third amended complaint. Hi, Antoinette. What are you doing, baby? I'd like to thank today's sponsor, Mint Mobile. Mint Mobile is challenging wireless industry norms. They've done away with a lot of the nonsense. There are no monthly bills. You don't overpay for features that you don't need. No BS, just premium service starting at $15 a month. One of the things I love about Mint Mobile is how they've changed the wireless shopping experience so that it's all online. You don't have any stores to deal with, any staff to deal with. Nobody pressuring you. You can sit at your own leisure and go through their plans and their features and their equipment. And like I said, with Mint, there are no monthly bills. It's bulk buying, so you buy everything up front. And the more you buy, the more you save. So they have 3, 6, and 12-month plans. And with Mint, you choose how much data you want. You're not stuck with a one-size-fits-all price in your plan. They start with 5, 15, 20 megabytes a month, or unlimited, depending on what you think you're going to need and how much data you're going to use each month. Also, their plans include some really cool features like free calling to Mexico and Canada, and also, believe it or not, to the United Kingdom. Plus, there's also included hotspot service, so you have a 10 megabyte hotspot service with the unlimited plan. And they have the nation's largest 5G network. They provide 5G coverage to 98% of Americans. And 4G LTE service to 99% of Americans. And you can bring your own phone if you want, or you can shop for new equipment on Mint's site, whichever you choose. But whichever option you pick, you get to keep your own phone number and all of your contacts. And Mint makes it really easy to switch. A lot of people have this misconception that it's going to be hard to switch. It's not. Mint makes it very easy. You can be up and activated within minutes from the comfort of your own home using an eSIM. And if you have any issues, Mint has excellent customer care, and 96% of Mint's customers rank themselves as highly satisfied with Mint's customer care. And to top it all off, all of their plans come with an unconditional 7-day money-back guarantee. I think Mint's great. I think you should check it out because I think you'll think it's great too. You can use this QR code that I'm putting on the screen here. It'll also be down in the description. And I really appreciate you checking out my sponsors. So thank you, Mint, for sponsoring this video. And then this is what the federal rules say. Under Federal Rule of Civil Procedure 15A, a party can amend a pleading as a matter of course once within 21 days of serving the original pleading or 21 days after the service of a responsive pleading or a motion under Rule 12B, E, or F, whichever is earlier. This means that if a motion for summary judgment is filed after the initial 21-day period, a party can still amend the complaint as a matter of course within 21 days of the summary judgment motion service. However, if the 21-day period has passed or the case is at a later stage, amendment typically requires leave of court or the other party's written consent. So they definitely need the court's permission to amend the complaint. And I'm sure that the girlies are going to object to this because they've basically defeated most of the counts that Janet and Lauren had against them. And like I said, there's just Lily Marston and 3 counts that were left out of everything that was filed in the complaint. So it seems a little sketch to me that not only did they not do anything before the summary judgment was rendered, but they then waited an additional 60 days before filing this with the court. That just seems absurd to me. So I'm going to show you now how they're trying to justify this. And we're not going to go through the whole complaint again. I'm just going to show you some of the red line sections of how they're trying to rework what they said, even though these things have been dismissed, to try to now revive them in an amended complaint. And just to let you know, I checked the docket again, and the parties have submitted what's called a status report. They've agreed to have basically some mediation with a magistrate that they hopefully will try to figure out if they can settle this case without going to trial. But in the interim, what the court has done is put a pause on the litigation. So even though this motion to amend the complaint has been filed, nothing's going to happen with it. And the court isn't asking the girlies to file their opposition yet. They're going to basically freeze everything while they go to a settlement conference and try to work it out without having to go to a trial. I don't know. Maybe they will work it out. That would be great to save everybody any more hassle with this. But I can't imagine the girlies are just going to quietly sit by and let them try to amend this complaint after the girlies have won summary judgment for most of what the Lauren and Janet were alleging against them. It makes no sense. So let's just take a look at what they're proposing to amend. And I mean, this thing is crazy with all the red lines. You'll see in a second. So you can see here is the motion to amend. And basically what they're saying is, the court issued the order on the motions to dismiss and strike, which included findings as to the sufficiency of the plaintiff's defamation, false light, and interference claims. Plaintiffs have amended their complaint in response to the evolving facts. Evolving facts. So I'm not aware of any new facts in terms of the allegations. So what they're saying now that the court has pointed out the deficiencies of their complaint and dismissed most of what they were alleging, they're now come to see the light, and they're going to try to now redo the complaint that was insufficient to begin with. The proposed third amended complaint reflects focused and streamlined claims based on the court's order and subsequent development. And they say that they're seeking to amend the complaint to remove Jessica Vasquez, so they're not even going to try to go after Jessica anymore. They're going to clarify the basis for their defamation per se claim against Rebecca Day, elaborate on Casey's intentional interference with plaintiff Propson's known business relationships, and emphasize Casey's statements were not justified. Now, they should have done all this in their complaint. Their complaint should have been what we call a well-pleaded complaint. So they should have said, oh, okay, well, maybe we need to beef it up. Let's nip this in the bud. We'll file the motion before the summary judgment is decided, and we'll ask the court, let us amend it. And then if they Girlies still want to file a motion to dismiss or a motion for summary judgment, they can do that after we file another amended complaint to try to correct what they're alleging is going to be deficiencies in the complaint. But no, they're waiting now until after the process finished and 60 days after that. So it's certainly not time. So they're basically saying, oh, we've learned now what the court thinks is wrong with our complaint. So now we're going to try to fix it 60 days after the court's granted partial summary judgment. And they say here, this amendment is not sought for the purpose of delay, but to ensure the pleadings reflect the actual scope and content of the plaintiff's claims in light of the court's prior rulings and subsequent harm suffered by plaintiffs. What subsequent harm? I can't imagine that they've suffered more harm since this case got started. So let's take a look at the red line version. And like I said, we're not going to rehash the whole complaint. I just want to show you. You can see here, third amendment complaint. You can see all the stuff that they've changed. And they've changed the wording to tortious interference with contract and tortious interference with economic advantage because defendant Day and Marston's publication of defamatory statements regarding plaintiff Braun and the defendant's public criticism that were harmful, offensive, and made for monetary and commercial gain. And then I'm just going to flip through. Some of this stuff is just minor, but like here they are now with Casey. They're basically pumping up what they said here now in the background, and we don't need to go through all the background again, but let's just go to now how they're revising their claims here. So they go through the allegations and they say that upon information believed, they're accused Ms. Propson of being transphobic in an attempt to incite community members to engage in cancel culture campaign against Ms. Propson. I think the court addressed that in their decision. So I don't know how that's much different from what the court decided. That the court had said it was opinion, that it wasn't defamatory because it was opinion, basically. That Casey's statements were made with malice and in an attempt to remove a business competitor. Okay, so Lauren the Mortician and Jeanette. So Lauren's a mortician and Jeanette's a lawyer, and Casey does commentary. How are they competitors? They don't cover the same material. They don't talk about the same issues. So she's not a competitor. Just because they both do YouTube doesn't make her a competitor. And they say that now, remember she said there was some endorsement deal, Lauren the Mortician, had said she lost allegedly some deal, but she didn't really give much specifics. So now she's saying that it was a contract with the Travel Channel, as well as brand endorsement contracts such as Pair Eyewear. And they're saying because the brands were alerted to the things that she had liked that were transphobic, that they didn't do the deals with her. But again, the court had said that things that Casey said and that some of the other things that were said by the other defendants, the court basically said it was opinion, that it wasn't defamatory. And it says on around the time, again, I'm just going through some of the stuff that they've changed and added here. It says on around the time Ms. Propson's Negotiations to start a podcast were also ended, so that's something new. In addition, Ms. Propson received an email from her sponsor, Pair Eyewear, stating, "We can't work with someone who has this kind of content out there." Now, if she liked certain things that people found offensive, so if you like something, okay, and this is my opinion, of course, you're sort of saying you agree with it, right? Otherwise, you dislike it. So if you like something and someone has an opinion that you liking that somehow connects you to that type of language or that type of discriminatory behavior, isn't that kind of a reasonable inference to make? You wouldn't like it if you didn't like it, right? In attacking the reputation of defense, so I think she meant to say in attacking the reputation of Lauren Propson, defendant Casey published social media videos using copyrighted material belonging to Lauren Propson without permission. In response, Propson retained attorney Jeanette Braun to assist in filing a DMCA complaint with Meta, which resulted in the removal of the Facebook posts. Following the removal, Casey posted a series of inflammatory videos, including one accusing Braun of filing false copyright claims and acting in bad faith as an attorney. Now, the claims against Casey were dismissed by the court. So now they're trying again to rework this. And one of the things we saw with the copyright claim board complaint that Janet had filed against Lily and Jesse, she lost her copyright claim. And the copyright board said, no, it's fair use. It's absolutely fair use. That what they used and how they used it, it was commentary, it was fair use. There is no copyright claim. So they're now trying to say, because Meta took the video down, that somehow that means that Casey was wrong about it being a false copyright claim. Well, not necessarily. Just because Meta took down the video from Casey does not mean that what she used was actually copyright. It could just mean, as the girlies pointed out in their motions, that Meta just didn't want to deal with it, didn't investigate it thoroughly, and just decided, to be safe, we're just going to take it down. That doesn't mean that what Casey used was actually a violation of copyright. So Lauren the Mortician maybe should try what Janet did and file something with the Copyright Claims Board. But my guess is it would come up with the same result. So that's probably why she hasn't done it. So that does not prove that what Casey said was defamatory, in my opinion. And they say that the statements Casey made were designed to incite her fan base, but they said all of this pretty much in the other version, and the court basically didn't buy it. And you can see they've made a lot of changes here through this document. And again, we're not going to go through all of this, but they're basically trying to say, okay, well, we see now how the court ruled. We know what the court thought was deficient. Let's now go back and rework all of this material in the complaint to try to conform to something we think maybe the court will find is strong enough to survive summary judgment. But again, like I said, they didn't file this motion to amend while summary judgment was pending, and they didn't file it until 60 days after the partial summary judgment was granted and the motions to dismiss were partially granted. So it's not timely. So if they don't settle in the settlement conference and the litigation is unpaused, and then this motion proceeds, and then obviously the girlie would file an opposition, in my opinion, I think the court is going to deny this motion to amend, again, based on what I saw and what I read and based on the circumstances. But we'll have to wait and see first whether they actually settle, which would be nice to just get this done with, or if they now proceed onwards to trial and then they try to get this motion granted and try to amend the complaint, which would bring everyone but Jessica Vasquez back into this. And basically we'd be back to the pre-summary judgment stage all over again, which I think is a delaying tactic, in my opinion, because again, it comes down to, why did they wait so long? Why 60 days after partial summary judgment was granted? Why wouldn't you file it when you knew that they were asking the court to dismiss or give them summary judgment, and then try to fix what the girlies were arguing were deficiencies before the decision came down? I don't know. So Let me know what you think down below. But personally, I think if this does go back to the judge, that they are not going to win this motion. And I think that they'll be stuck with just Lily Marston and the 3 counts that were left. And if Lily can show, because they had said that her reasoning for why the statements that she made weren't defamatory, basically she had made some assertions that she didn't support with additional information the court pointed out. I can't remember exactly what the language was, but I think if she can show that the copyright claims actually would have been fair use, then she may be able to overcome those last 3 counts. We'll have to wait and see. But again, they're going to have the settlement conference. If it works out, great. That's the end of the lawsuit. If they don't, then we're going to have to see what the court decides on this motion to amend the complaint at this very late stage. Let me know again down below what you think. I really appreciate you guys tuning in. Squirt is here falling asleep. Sybil's falling asleep. Everyone wants to go to bed. Thank you so much, you guys, to all of our Patreon patrons. You guys are so great in helping us with the monthly vet bills for the cats. I really, really appreciate your help. And I appreciate all of the channel members for the same reason, for your continued support. It means so much to us. And those of you who send stuff from the Amazon wishlist, thank you so much for your generosity. You guys are awesome. We have the greatest community, I think. And I love that you guys love the cats too, in addition to the commentary. So thanks again, you guys. I have a video that I have made responding to the TikTok psychics trashing of me, basically. And we're going to go through that in the next video. So be on the lookout for that. But in the interim, take care of yourselves, love one another, and I will see you in the next one.
Pretty please. Subscribe, like, and hit the bell. I get a treat for every new sub. Thank you.